So we are delighted to have with us today a Republican from Idaho who is not a member of Congress. She's the chairman of the United States International Trade Commission. Originally nominated to be a commissioner of the ITC by President Clinton in '99, she has also served as vice chairman of the agency. Prior to her appointment, Deanna Okun served as counsel for international affairs and trade to Senator Frank Murkowski of Alaska in connection with his position on the Senate Finance Committee. She also handled international energy and foreign relations issues with an emphasis on East Asian affairs. Prior to her work on the Hill, Ms. Okun was an attorney with Hogan and Hartson and with the Competitive Enterprise Institute. Chairman Okun holds a bachelor's degree in political science from Utah State and a law degree with honors from Duke. She and her husband, Bob, also known around this town, have two incredibly accomplished teenage daughters, which I'm sure she'll be happy to tell you about offline. Please welcome Deanna Okun.
Well, good afternoon. Thank you, Kathy, for the introduction, and thank you to CCIA and to Ed for inviting me to be here today and to tell you a little bit about the International Trade Commission and how our work impacts the computer and communications industry. And I will also look forward to, I'll give you some remarks, talk about the agency, and then hopefully have some time for questions as well. I looked at the agenda of speakers today, and I know that you have had a list of very influential policymakers. I believe my friend Demetrius Morantis from USTR also on your list today. So I guess in addition to my standard disclaimer that the remarks I make today are my own and should not be attributed to the Commission or any of my colleagues, I would also note that the ITC as an independent agency is fairly unique, even for those of you around the table who are pretty familiar with Washington. The Commission was set up in a manner that it preserves our independence, including that you have an even number of commissioners, 6 commissioners, no more than 3 from either party. The chairmanship rotates every 2 years between parties. It doesn't matter who the president is. And it's an agency of about 400. So by statute, even though the 6 commissioners are political appointees, and Kathy went through how I made it to the commission, we are not policymakers, nor is the International Trade Commission a policy-making body. So keep that in mind when I talk about some of the legislative proposals that are out there that may impact the ITC. And again, we are a creature of Congress. We were set up with 2 major statutory missions. The first one is to adjudicate trade remedy cases, Section 337 investigations, which involve the adjudication of unfair acts involving imports. These investigations typically involve the assertion of patent rights primarily against alleging infringing imports, but can also involve trademarks, copyrights, trade secrets, or other unfair acts. We also adjudicate Title VII anti-dumping and countervailing duty investigations, where we determine whether a domestic industry is materially injured or threatened with injury by reason of dumped or subsidized imports. We also provide analysis and reports to the Congress and to the President. The members of Congress who you've heard from today, USTR, such as Demetrius, they are our statutory customers. So we provide objective analysis to them in the form of written reports and technical advice on trade and economic matters in response to a request from House Ways and Means or from the Senate Finance Committee or from USTR. We are also involved in assessing the economic impact of free trade agreements. So when a agreement is being negotiated or after it's signed, the ITC prepares economic analysis to provide to the Congress, and prior to negotiations, often provides reports to USTR to help them assess where they should be negotiating. And we also provide trade policy support to the executive and legislative branches, technical data and analysis. We draft annexes and proclamations. And then finally, we maintain the harmonized tariff system of the United States and work on that. So I'm going to focus the remainder of my remarks today on those parts of our mission that I think would be of most particular interest to your members. And let me start with Section 337, and I think with a little bit of what it is and what it is not. And I think to start with the fact that Section 337 is a trade statute, right? It's not an IP statute. It was originally enacted in the 1922 Tariff Act. And the original statute, and then when it was reenacted in 1930, don't mention patents or other IP rights, but even from the beginning, the earliest cases involved patent infringement allegations as to unfair acts or methods of competition. It's directed to unfair traded imports. So again, no relief against domestically produced goods unless they're produced abroad and imported. Section 337 provides no monetary damages. The sole remedies are exclusion orders, both limited and general exclusion orders enforced by customs, and cease and desist orders. And in fact, when the statute was changed, monetary remedies were taken away. So the only remedy, if there's a violation at the ITC, is an exclusion order. We are not a substitute for district court adjudication of patent infringement. Section 337A1 specifically states that the section is in addition to remedies available under any other law. And finally, our decisions are not binding on district courts. So while there may be parallel litigation, district courts may look to our decisions for persuasive value, but they are not binding. So there's been, as we were talking about earlier, the ITC in Section 337 has I guess, increased in popularity if you look at our caseload, and increased in scrutiny if you look at the number of proposals and of other conversations going on the Hill and elsewhere. So let me talk about how we perceive why there's been an increase in the caseload at the ITC based on our discussions with IP rights holders. First, and it's certainly not news to the folks sitting around this table, is the increasing importance of intellectual property and innovation to the competitiveness of the U.S. economy. U.S. IP rights are estimated to be worth upwards of $5 trillion, more than the nominal GDP of most countries. IP-intensive industries account for more than 1/2 of total U.S. exports in the last decade, and that share is rising. So again, a very important part of the U.S. economy. IP rights holders tell us that one of the most important reasons they come to the ITC is our relatively quick resolution of patent disputes involving imports. Last year, the average length of a Section 337 investigation completed on the merits was 13.7 months. By contrast, the average length of district court patent cases completed on the merits was 35.3 months. You go to trial at the ITC in about 10 months. So for products with short life cycles, prompt relief from infringing imports is imperative. It's no surprise then that our cases continue to be dominated by complex technologies in products such as smartphones, tablets, other computing devices, video displays, semiconductors, devices, and other high-tech products. And then the final reason that is often cited to us on why the venue is popular is that our judges and lawyers who work on these cases, both at the administrative law judge level and at the commission level, have significant expertise in patent and other IP laws, as well as experience in complex technology. It's all our ALJs do. They just do patent. So unlike in a district court where they have to resolve other cases and focus on other things, the folks that are at the ITC have patent experience and expertise, and if they're there, they want to be there. So how have we managed this increase in caseload? And again, I went to the commission in 2000. Since 2002, we've had an increase of more than 350%. This is driven in large part by the smartphone, computer, and other electronic patent disputes that I mentioned before. For fiscal year 2011, we instituted 70 new investigations. We're on track to reach or break that level this year. We've already voted to instigate 34 new investigations as of today, and we have 108 active matters. Fortunately, we are fully staffed. We have 6 administrative law judges. We increased the staffing for the administrative law judges, so they each have 2 law clerks assigned to them. We've added lawyers in our general counsel's office. And we are also fortunate that we're able to add a 3rd courtroom. And we broke ground last week and expect to have a new courtroom for again, focus for Section 337 issues operational by Labor Day. We are also undertaking revisions to our rules of procedure, including e-discovery, which we've heard a lot about, in different forums, including at the district court and the federal circuit. Our objective is to improve the Section 337 proceedings and ensure that we continue to provide expeditious adjudication of IP cases, because that's what Congress tells us to do. We've also developed an improved investigative database, so those of you who are familiar with the ITC or have had the opportunity to go on our website, we're trying very hard to provide the public with updated information. And if you happen to go on to look up these investigations or some of the reports I'll talk about later, if you would take the time to fill out our survey, it would be helpful so that we can continue to improve our operations. I'm going to touch on a couple of issues, and they may have come up from some of your earlier legislative members who spoke to you today. But I might start first with domestic industry. So domestic industry in Section 337 is an essential element. It makes it different from if you were in district court. It is a trade statute. Under the statute, complainants can satisfy the domestic industry requirement with respects to articles protected by the patent or IP right by demonstrating significant investments in plant and equipment, significant investments in labor and capital, or through substantial investments in the exploitation of IP rights, including engineering, research and development, and licensing. So in addition to manufacturing industries, we also see complainants whose industry is focused on research and development or licensing. When the ALJ and the Commission are looking at these cases, the domestic industry analysis is very fact-intensive, and we look at the facts of each case when making a decision. In a number of recent cases involving licensing industries, the ITC carefully examined the many facts involved, and in the cases that have gone forward, found that the complainants failed to establish the domestic industry. For those of you following these cases, this would be coaxial cable connectors, our 650 case, and multimedia display and navigation devices, 694. And at least the 650, the coaxial cable connectors, went to the Federal Circuit, and the Federal Circuit approved the Commission's analysis of domestic industry on the facts of that case. So also related to domestic industry, there's been a lot of talk about NPEs, or non-practicing entities. And should start with saying that I think there are a lot of definitional issues involved with that. When I first heard the term patent troll when it came to the Commission, I kept asking someone to give me a definition and tell me a company that fit it, and I got a number of evolving definitions, and I continue to get that. But to the extent there is a lot of discussion right now about whether non-practicing entities, and I think really more particularly patent assertion entities, should be allowed to bring cases to the ITC, I thought it might be helpful for me to, again, we don't take a position, we're not policymakers. If they change the statute, we will enforce whatever statute is, whatever the statute reads. But I do believe there have been misconceptions about NPEs and PAEs at the Commission, and so I wanted to share some of our own facts about that. And just starting again with the fact that the statute was amended in 1988 to allow non-manufacturing entities to bring cases at the ITC. In particular, Congress made note in amending the statute that inventors, universities, and other entities that conduct R&D, engineering, or licensing are equally entitled to relief. In fact, one of the motivations behind the amendment was to overturn ITC earlier decisions where Congress believed we were implementing the statute too narrowly. And in fact, the case that led to the changes was with respect to a licensing entity, Warner Brothers, in connection with their copyrighted Gremlins products. So looking at the statistics that the Commission keeps, and again, I'll reference statistics since the eBay case decided by the Supreme Court, because that's where most of this discussion starts, is whether that's driven cases to the ITC. Since May of 2006, when eBay was decided, the ITC has instituted 258 investigations. Of these 258 investigations, only 21, or 8%, involve complaints that were filed by PAEs. Only one PAE has ever been successful in obtaining an exclusion order at the ITC, and this was Rambus, in our case 337 TA 661. As for NPEs, there have only been 26 investigations, or only 10% of those 258, and only 2 NPEs were ever successful in obtaining an exclusion order, Tessera and Unimed Corporation. Tessera you're probably familiar with. Unimed is the technology transfer office of the University of Nebraska Medical Office. And I would note that in all 3 cases involving NPE or PAE complainants where exclusion orders were issued, the NPE or the PAE itself developed the technology protected by the patents asserted in these investigations. Now, we have also heard that NPEs and PAEs use the ITC to extract settlements. And again, just looking at statistics, it's difficult to decide whether that's an accurate statement. For the statistics we've collected, overall settlements for all the investigations were 49%. So about half of all our cases settled, which is slightly below the district court percentage. The settlement rate was lower for cases involving NPE complainants. That was 38%. But for PAEs, again, a much smaller proportion of the total number, the rate was 61%. But for all other non-PEs, non-NPEs or non-PAE complainants, the settlement rate was 51%. So not much deviation between all of those. You may also be familiar with the FTC report issued in March 2011 entitled The Evolving IP Marketplace, Aligning Patent Notice and Remedies with Competition. This report makes policy recommendations regarding the FTC's view of competition policy and patent remedies. It includes policy recommendations that the ITC's issuance of exclusion orders should conform to district court issuance of permanent injunctions which apply the eBay four-factor equitable analysis. The ITC takes no position on the FTC report, but as I noted at the outset, we are not a policymaking body, nor do we formulate policies. And I would note that the Commission is bound by law to investigate allegations of Section 337 violations, and if a violation is found, the statute states that we shall impose a remedy unless the public interest factors that are set forth in the statute counsel otherwise. And again, there is also a review by the President on broader policy issues, in addition to the Commission's review. So we do not see ourselves as in a position to promulgate policymaking or substantive policies as we implement Section 337. With respect to public interest itself, some of you may be aware that the ITC has embarked on an effort to have a more fulsome record on public interest. And a number of reasons for that, but most particularly when it comes time, if there's a remedy and we have to determine whether public interest would counsel that an order not be imposed, we wanted to have the fullest record possible for those cases where it was going to be a big issue. So we've published our final regulations in October of 2011. Since we've implemented this new practice, we've delegated the public interest to the administrative law judges in 14 of our cases. Several of those have settled, but there are 7 pending, so we haven't yet had a case before us where the record was developed or delegated to the ALJ. And then I would also just touch on RAND and FRAND cases as being an emerging issue. There's a handful of cases before us involving standard essential patents. The issue here revolves around the patent holder's commitment to standard-setting organizations pursuant to the SSO's policies to license these SEPs on reasonable and non-discriminatory or RAND terms. And so I can't comment any further because these cases are in litigation, but if you're interested, I'd say stay tuned and look for our decisions. You might have also heard from Senator Wyden, and I understand that Chairman Issa is next on your agenda, discussion about the Open Act. And whether the Open Act is passed or what its final form will be, I would, of course, leave to the members of Congress who you will be hearing from or have heard from. But, of course, it does include in its current version a significant and new statutory mandate for the ITC to investigate copyright and trademark infringement via Internet sites owned and operated overseas. I think the only thing I would say as chairman of this agency, and having served there for 12 years, is that if Congress offers us a new mandate and provides us the necessary resources, then the Commission will approach this new mandate with the same can-do spirit we have any time we've had a new statutory mission given to us, and we would be prepared to do so. So let me move off the adjudication and onto some of the reports which might be of interest to this group. First, we did 2 reports in response to a request from the Senate Finance Committee on Chinese IPR practices. We were asked to study the economic effects of copyright, trademark, and patent violations in China. One of the unique things about an ITC study is we have the authority to issue questionnaires. In that case, we sent out over 5,000 questionnaires. Some of you may have received them for industries operating in China. Among the findings, we found that U.S. firms in IP-intensive industries reported losses from $14 billion to $90 billion. And then another finding is that if China improved its IP protection to U.S. standards, U.S. employment may increase up to 1 million jobs, depending on labor market conditions in the U.S. We also have another study on global supply chains. We delivered this to USTR in August of 2011. know you've had some discussion about that and the growing importance of global supply chains. Two things I would point out about that study. We had 4 case studies in there: apparel, motor vehicles, televisions, and logistics that helped, I think, really illustrate the divergent ways U.S. firms engage in and often lead global supply chains. And the other thing I would point out from that would be that the finding that the United States has the highest percentage of returning value added of all countries. So U.S. workers and companies contribute 89% of the value of all goods and services used in the economy, and they contribute a similar share to U.S. exports. The study also contains what I think might be familiar to many of you, the economic study of the iPhone and where the value added is and why that still shows why global value chains matter for the United States and where the value comes from. So also available publicly. Briefly, before we turn to questions, let me mention 2 other reports. One was on small and medium enterprises. We did this for USTR, a series of 3 reports. We identified the impediments to small and medium enterprises exporting, such as protecting intellectual property, obtaining financing, locating foreign products, foreign taxation, and all these things disproportionately affecting small and medium enterprises. We have a number of roundtables that the Commission hosts to bring together academics, members of industry, members of staff from Congress, from both the House and the Senate, to talk about issues that are coming up in trade agreements or otherwise. For trade and services, we've had 2 roundtables, one in November of 2011, one in 2010. We talked about the challenges of regulatory harmonization, the services contribution to global economic activity and how to handle it. I'm sure it's something your members are very familiar with. While trade and data has problems, trade and services is extremely difficult to collect and analyze, and the Commission has been working with a number of government agencies and international organizations to do a better job of evaluating services trade as part of trade agreements. And then we've also done a number of projects in trade and advanced technology products. The ITC held a symposium in 2009 in Beijing, which was co-sponsored by several China-based academic institutions and looked at a number of the innovative issues facing high technology products. Next month, June 13th, or 2 months, I guess, June 13th, the Commission will be hosting its 2nd high-tech roundtable. Some of you may have participated in our first high-tech roundtable last year. If you're interested in participating, we'd love to have you. Again, the goal there is to look at issues where the Commission could make a contribution, either in analyzing trade in those goods for purposes of ongoing trade negotiations or in helping our policymakers and our trade negotiators determine where to focus their energies. So with that, I know I went through that fairly quickly, trying to cover a lot of what the agency does, but I'd be happy to take questions and respond where I can. Yes.
Thank you very much for coming to speak. I think you went into, in some depth, the studies that you guys perform, and I know you respond to requests from Congress, but I think you also independently come up with studies. Is that accurate, or is it just?
We independently do staff papers in emerging areas.
And we have some representatives of our Geneva office here who work with the WTO, and we've been doing international trade for almost our whole existence. But one of the things we're finding difficult is statistics are the currency of trade policy. In our realm, there's not a lot of good statistics. We know through anecdotal examples of the effect of blocks on internet access in foreign countries and things like that. But I was wondering if you could speak to, I guess, kind of what you guys are doing in the future about developing more stats around services, around the cost of 21st century non-trade barriers, and kind of maybe ideas from where to go forward can help our industry.
Yeah, well, I would love to have you come over and talk to the folks who head up services and high tech as well, and share your ideas. Because certainly from a strategic vision for the ITC, one of the things that we know is, we were set up as the Tariff Commission, right? During the Civil War, the history of the ITC is, back to, trade in when the South, wanted to export and the North was trying to protect its then textile industry. So, but we all know that that's not the world we live in now, and that while we can model tariff reductions really well, the world is the world of trade in services, in internet, in online services, and it's just as you say, the data is not good. However, we have a number of initiatives underway trying to figure out how can the data be collected if it's not there? Who should be in charge? I mean, what's the right entity? And then also, what kind of data could you take to put into what have been kind of traditional economic models? And can that generate the type of information that's really helpful in trade negotiations? So for some of our more recent reports, we have included some trials on looking at, for instance, the insurance industry and trying to look at non-tariff barriers and say what would be the impact of removing non-tariff barriers? What's the impact of trade facilitation on the flow of services? So, but all those areas are ones where we need industry, because you're on the front line, you see it, to help us. So I'd encourage you both through our roundtables and otherwise to come to the commission, share what you see, what your priorities would be, because again, we're a government agency, it's a tough budget environment, and we need to prioritize what we do. But we certainly see the issues that you talk about as being part of our strategic initiatives going forward, and have some really smart people working on it. Thanks. Yes.
Yes, ma'am. Thanks for coming. Ron Yokovitis with Data Foundry.
Okay. Yeah, just met your colleague.
We do services, and I've looked on your website, pending investigations and litigation. I don't see services. I only see products. And of course, we get tangled up on the services side.
Right. Yeah, so we might have there are parts of the website where we'd be very specific about our services, the work we do in services, because we do a report, an annual report on trade and services, and I can get that for you and show it to you. The other issues that you're talking about on products is mostly the adjudication side of what we do. So whether we're doing intellectual property or dumping cases, those are all products. But on our research side, which is a third of what the agency does, we have an entire division. Richard Brown is the head of the services, and they are preparing reports, preparing staff studies. And so, again, I would talk with you afterwards and hook you up with those to find out if there's some information there that might be helpful to you. Because it is important, we know that. And our negotiators know that, and the policymakers know that. I should say I was on Capitol Hill earlier in the year presenting some data that staff was working on, trying to look at kind of value chains and headquarter impact on employment from services industries, because again, even on the employment side, it's hard to get good statistics. And so we went to the Hill with that information to try to figure out if that's the type of information policymakers and our negotiators would find helpful, either for TPP or for other negotiations, and just for business generally.
Just one more comment on this statistics issue and the studies. In the study you mentioned about China, which you said it was again a survey where people self-reported the impact of infringement. When I read that study, what sort of leapt out at me was, on the one hand, there were, let's say $40 billion or whatever of cost of infringement, but what was even more interesting, that's of course a soft number, but what was a hard number was the cost that those companies invested in enforcement.
Right.
And the fact is that they were only investing something like $4 billion in enforcement. And so you sort of say, well, if you're a business and you're experiencing $40 billion of loss, but you're only spending $4 billion to mitigate that loss, there's a problem. I wonder if you have any thoughts about that. Well,
it's interesting. I mean, one of the things that we tried to do in that report, again, for a number of those statistics, and you point out an important one, is to just, we did think it was helpful to have questionnaires where companies did self-report, and you can say that that underreports, and it probably does. But just to point out gaps like that, and I think we tried to do that throughout the report, is to where there are discrepancies between investment and return, or where in fact the greatest threats were in terms of violations, because then that would help not just businesses, but our negotiators, our embassy over there, try to focus on what is most important to business. So, I can't say I think it was perfect in how we collected data, but I think it did help point out a number of issues, including the one you identify. And the other thing which I didn't note when talking about that study as well, is while we did do questionnaires to get the self-reporting from companies, we also, our economic team also did a couple of different models. So to try to see whether it validated those numbers, and that related to the employment numbers as well. So we try to, in all our reports, try to do both economic modeling, which is theoretical, but then also try to have real-world either case studies or collecting information from industries to find out what's happening on the ground. And does it, do we see any divergence there? But thank you for that observation.
Let me, well, go ahead.
Oh, I wanted to ask, I guess while we're on the statistics trend, I'm not certain if this information's been gathered, but it seems to me that particularly during the uptick in the smartphone wars and other sort of litigation food fights we've seen, that there's a fair number of incidences where ITC litigation is being pursued more or less simultaneously with district court litigation. And maybe that's just observation bias, because that's the cases I'm reading about. Has the ITC done any sort of tracking about the frequency with which there is parallel litigation before the commission and in district courts? And if that data exists or not, what would that tell us?
Okay. I should have at the outset introduced Juliana Cofrancesco, who's here with me and who is in charge of intellectual property issues in the chairman's office and has a long history. One of the things that she's done while I've been chairman is we have been putting in place a data gathering for the agency to try to make sure that we know what's going on. So let me ask her on the, obviously there often are dual cases going on. I don't know if that statistic, if we have it or if you know it, Juliana.
We don't have that statistic, but we do know that parallel litigation is common. It's common to file it. In fact, there was a change to the statute a number of years ago that permitted respondents who are the corollary to defendants in these cases to file a stay in the district court so that the ITC proceeding can go first through the appeals, and the district court case, so long as it's parallel to it, is held until the time that the ITC case runs its course. Similarly, there are also worldwide actions being taken in the wars that you're talking about in Germany and elsewhere.
And I'm sure I know Chairman Issa is your next speaker. You might want to ask him that question, because I know from our discussions with him, he has some views on that particular subject as well. But again, the law allows it. As I stated at the outset, Section 337 is a remedy in addition to, because it is a straight trade statute, not an IP statute, and you can't seek damages there. So for some companies, I think it makes sense. If they're facing importation, the best remedy is just to seek an ITC exclusion order to stop it at the border if you have a short life cycle. For other companies involved in this, what is a global war, as Juliana observes, they're, for any of the lawyers in the room, they're firing on all fronts. You might have had other speakers who've come through, and we've had some of the commission just talking about kind of the history of patent wars throughout time. And I think it's kind of interesting because, you do see, and I think you'll see it here, and I'm probably going beyond my normal non-policy, not saying anything, but, you often have with these complex technologies, as you did when the telegraph was invented, you have wars until everyone sorts out who owns what and what the licensing arrangements are. But, so we've seen spikes, and I think we're in the middle of a spike, and I don't know, it's hard to predict what the next technology is, since we've, right now we see the tablets in there and the smartphones. Oh. Yeah.
Let me, I know you say you're not policy, okay? And I understand that, and nevertheless, I'm going to get to what, the end of my question will be, to what extent do you maybe get involved in interagency discussions on intellectual property issues? But let me prelude that with, my industry cares greatly about this. And our association, we care greatly about intellectual property. It's very important. It's very important we get it right. And I think I've often seen companies because of specific battles, somehow they're on this side one time, and maybe a couple months later, they may be a little different. They all think it's important, and can get caught up in it in a positive or negative way. But even though it's very hard to do, I think there's also a broad consensus that there's real needed reform for the underlying substantive law in the intellectual property regime. Again, not everybody's going to agree on which direction to do that, but we are dealing with regimes which are designed for certain purposes of promoting innovation. There are many studies that in some ways they wound up becoming counterproductive and inhibit innovation and drain resources. You all, because of your role, you have, frankly, a very unique window into how companies really react to that, and I guess to what extent you really probe inside companies as to the extent that when they develop patents, for example, whether I'm getting at the quality patent issue, to what extent, whether they think their patents are really important or whether it is part of a game. I mean, the number of patents that are issued has mushroomed and globally. I mean, China is now getting into the game in a massive way. And we always get a little frustrated when people try to identify a measurement of innovation by the number of patents, because we think that's ridiculous. Anyway, I guess with your experience and your base and your involvement with companies, and do you have a voice in interagency policy? And it's not your role to make policy, but you have insight. I'm just wondering how that plays out.
Right. No, I appreciate the question, because it is true that the agency, I think, is regarded, and I hope continues to be regarded as objective, both on the adjudication side, but in the analysis we do. So, to the extent there is legislative or other changes being considered, we can be consulted, because what we can provide is the information that we have and what we've seen in a technical way. Again, because I think the interest of everyone, and again, you can, I think there are really important questions being debated about innovation policy, and I know you're involved in many of them, and I've been reading some of the work. What we can bring to that is statistical help, information about what we see, the number of patents, what is going on, so that people are working off, what we hope they're working off is accurate data as opposed to anecdotes. And, because, I mean, I worked on the Hill, you know this, I mean, sometimes you get one bad case that, that ends up changing the law. And, I think our goal as an agency would be, we hope that when any of these things are being considered, that we will be consulted so that we can provide what we've seen and what our statistics support. And then, then it's up to the companies in combination with the policymakers and the executive branch to say, okay, having seen all that, this is the change we think should be made. And then it's, it's the way Washington should work. So, a little convoluted, but I hope that answers the question.
So I know that you, too, were interested in hearing from Chairman Issa, but he is delayed by the very same votes that Congresswoman Lofgren had to run back for. So you're welcome to stay with us as long as you can.
Okay.
But I think Ed probably has a different plan right now.
Excellent. Well, I want to say thank you very much for listening and for your questions. And if there's anything specific about the ITC or our website or getting our products, we'd be happy to point you in the right direction. Thank you for having me.